In this video, we're going to talk about the Supreme Court of Canada. The Supreme Court of Canada is the highest court of appeal in the land. Its job is to review decisions that come from the lower courts. If somebody feels they've been wrongly convicted, if they think the police illegally obtained evidence, they can appeal that through the provincial courts of appeal all the way to the Supreme Court. Now, to be a judge on the Supreme Court, you have to have at least 10 years of experience. This can be as a judge or from the practicing bar. To get there, you're appointed by the Prime Minister, and in Canada we have mandatory retirement at the age of 75. The Supreme Court is led by a Chief Justice, who doesn't have any more power than the other judges, but they act as kind of a central clerk to coordinate some of the activities and the opinion writing. And our Chief Justice is Richard Wagner, who was appointed initially to the bench by Prime Minister Harper, and then promoted to Chief Justice by Prime Minister Justin Trudeau. The Supreme Court and other courts in Canada are organized along the principle of judicial independence. We want judges to be able to adjudicate and rule on cases without interference. They have security of tenure. They can't be fired. They're there. It's essentially a lifetime appointment, only for us in Canada that's 75 years. Financial independence. Their salary cannot be controlled by Parliament or any level of government. So therefore, a Prime Minister could not threaten to punish judges by withholding salary or anything like that, or unfairly reward them. And they're free from political interference. The Prime Minister or another branch of government can't tell them what cases to rule on or what cases to ignore. In Canada, the lower courts, the provincial courts, have typically been a vehicle for patronage. And a patronage is when a Prime Minister rewards their friends or party allies. However, the Supreme Court tends to get good judges. Patronage is a little more rare because there's so few qualified applicants. Now, typically the Prime Minister would pick whoever they wanted, but that process has been refined over the years. In 2006, Prime Minister Harper established a committee, a parliamentary committee, that would interview justices. It wouldn't necessarily have a vote or a veto, but the interview process would allow Canadians to see and review the judge's credentials. Justice Marshall Rothstein was the first judge to go through this process. In 2019, Trudeau added more changes by establishing an independent advisory board that would recommend Supreme Court candidates to fill future vacancies. Now, in Canada, to be fair, that judicial appointment process is pretty boring. There's not a lot of partisan bickering about the candidates. The candidates are generally well qualified. However, in the American system, it is much more partisan, especially with the nature of the two-party system with the Democrats and Republicans. The Supreme Court is a very powerful institution, and therefore the nomination hearings are bitterly fought, and they often devolve into spectacles. Justice Kavanaugh, for example, was one of the more recent appointees to the Supreme Court, and his confirmation hearing was quite notable for the Democrats trying to dig up some details about his past, and then Justice Kavanaugh himself having a virtual meltdown on the stand and yelling at the Democrats on the committee. So that tends to be how these hearings work in the United States. Much more partisan, much more emotionally charged. One of the key issues in the American system is Roe v. Wade, which is an abortion case. The two sides, the Republicans and the Democrats, are really trying to find out how these judges are going to rule on a future abortion case. With the Republicans looking for judges that will be more restrictive in terms of adjudicating cases about abortion rights, and the Democrats want judges that are going to be a little more pro-choice. Now, in Canada, the closest thing we've really had to a judicial scandal was trying to fill a seat with a judge that wasn't really that qualified. What I mean by that is that some of the seats on the Supreme Court, 3 of them, are designated as Quebec seats. Those seats must go to a judge that is practicing in the Quebec system because they use a slightly different civil code compared to the English common law system. Now, what happened was when a vacancy came up in one of those Quebec seats, Prime Minister Harper selected Justice Marc Nadon, who is very qualified, exemplary jurist, but he was a federal court judge. He was not a judge in the Quebec system. However, he was from Quebec. So the Prime Minister said, well, this guy's from Quebec. This is a Quebec seat. And his appointment was challenged, saying, no, this Quebec seat has to be a judge from Quebec. And this counted as basically a Canadian controversy. There was a reference about this, and that meant the government asked the Supreme Court to rule on whether this guy could join the Supreme Court or not. And they ended up saying no, that this did not count as a Quebec judge filling a Quebec seat. And Justice Nadam was not allowed. He was ruled ineligible for the court. Just to recap, in Canada, the Supreme Court judges, they're appointed by the Prime Minister. There is no approval by the Senate like there is in the American system. Judges serve to age 75, and then there's mandatory retirement. The appointments in Canada are relatively uncontroversial, especially when we compare them with the American system. We get good judges in Canada, perhaps because the process is less partisan and frankly somewhat boring, that tends to produce good judges.